Hello, everyone, and welcome to another episode on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm very excited to have you join us today. But before we move ahead, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And today is going to be another exciting session today, friends. Thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X, also known as Twitter earlier. So thank you so much for joining us. And let me tell you that you can also participate on this session by commenting, and not only commenting, because I have this number where you can dial in to call us, to participate and have a direct conversation with our attorney, and that is the number is 425-436-6335. And when they ask for the access code, all you have to do is dial in 988-888 and just say hello. We'll be able to hear you. So thank you so much, friends, for joining us. And yes, as many of you know, that H-1B visa is a very critical pathway, for foreign professionals seeking to work in the United States. And it's been subject to various updates and changes over the years, and even in this year itself. When we saw when we look back. So in today's webinar, we will be diving into these new requests for evidence, or RFEs, that are expected in H-1Bs in the year 2025. And these RFEs can be quite challenging, and understanding what to expect is key to ensuring a smooth application process. And of course, to help us understand and explore these better, especially this topic better, I'm really thrilled to have with us none other than a very experienced and knowledgeable immigration attorney who has been, with us for a long time. And yes, it's very nice to have attorney Chand Parvathaneni from Dallas, Texas, SPB law firm. Chand, has been a trusted expert in business immigration, and he's here to shed light on the potential RFEs, how they may affect H-1B petitions, and most importantly, how to prepare to avoid them. So, thank you so much, Chand, for joining us today. I'm really excited for today's session.
Sure, Nipasa. Thank you so much. And in general, I mean, we're entering a new year, 2025. And what's different this year is we're going to have a new president. We're going to have a new administration. So a lot of things, more than likely, are going to be done a little bit differently. Nothing is going to change drastically because there are rules out there. There is a process out there. But the way the things are handled could always change. The priorities of the new administration could be different. So what that means is the way things are done are slightly going to be different. Will they completely stop H-1B? No, it's not going to happen. So things will still continue. The only thing is the parameters, the way the regulations are interpreted. So those kind of things might change. And
Mhm.
what that also means is in the last 4 years, we had a Democratic administration. And prior to that, we had a Republican government under President Trump. And we have seen how things happened between 2016, 2020 time period. We've seen a lot of memos, USC has memos being released during those 4 years, also during last 4 years, and so on. And what that means is every time you have a new administration, they're always looking at how things were done in the past. They're trying to look for ways to refine the process. And every administration has a different way of doing things in a format where they think they're going to get things more refined. And from that perspective, and from the priorities that the new administration is coming out with, we do anticipate maybe some challenges, maybe some refinement. Some things will get a lot better, some things will get a lot worse, and so on. And we're going to use this time today to discuss the upcoming challenges and what kind of RFEs, especially as it pertains to the H-1B world, what kind of RFEs employees can expect and how they can try to be ahead of the curve and be proactive in making sure they're not completely caught off guard and doing things the right way, complying with the law. Because as long as
Mhm.
people comply with the law and they meet all those requirements, in general, nothing majorly should change.
Mhm. Right, right. Thank you so much, Chand, for giving us an overview kind of, for what we will be covering today. And we are looking forward, definitely. And well, we have Mayan, who has a comment already on Facebook. I would say just stay with us, Mayan. We are going to address your questions. And all you folks out there, yes, you can comment. And remember, you can also dial in, you can call us to have a conversation with us, and especially with Attorney Chand today. So the number is on the screen, and we are here. And I think without further ado, Chand, let's move on with our questions that we have for today. And my first question to you is, what new trends are emerging in the types of RFEs being issued for H-1B petitions in 2025?
So the trends in request for evidence issuance for H-1B petitions, they keep on evolving. And as we approach 2025, I think we're already seeing some emerging patterns that could shape the process. And I think what's going to happen in the last 4 years. So prior to 2020, when we had the old President Trump's administration, and also when we had President Obama in the office, there was a lot of focus on employer-employee relationship. So pretty much majority of the RFEs were about employer-employee relationship, looking for client letters, looking for vendor letters, looking for contracts, and so on. And starting 2021, the focus on employer-employee relationship decreased a lot, at least in the terms of the RFEs that we are seeing. The reason is there was a lawsuit in 2020, and then USCIS went back and rescinded a couple of the old memos. So the focus changed from employer-employee relationship to a lot of other things. And what we have been seeing in the last 4 years, uh, a lot of focus on the beneficiary qualifications, a lot of focus on the degree requirements, the educational qualifications of employees, the work experience, the nature of work experience of the employees, sometimes specialty occupation. So these are the kind of things that we have been seeing in the last 4 years. Starting 2025, I do expect more focus again on employer-employee relationship, and especially when you have jobs involving a third-party work site. So a third-party work site is where you have an IT services company or an IT consulting company. They place their employees at a third party, so at a client location. Those kind of cases, I do expect renewed focus again on employer-employee relationship. How that will happen, we don't know. Whether we'll have some memos or whether the government is going to follow the Administrative Procedure Act and change a couple of things. How they will do it, we don't know. But I can definitely expect some additional RFEs on employers' supervision, their control, and how the control happens, especially when you're on a third-party work site. So definitely renewed focus on employer-employee relationship more than likely will come back again. And also the specialty occupation scrutiny. So we are slowly seeing trends where we are seeing more and more RFEs again slowly increase on the specialty occupation side. So the specialty occupation RFEs, their entire focus is this job even a complex job that you really require a H-1B? That is what is typically what a specialty occupation RFE says. They are targeting the nature of the job, that they are trying to see if the job is really a complex job that really requires a bachelor's degree in a specific field. So these kind of RFs tend to ask for more detailed job descriptions, look at what exactly is happening in the industry, look at the industry standards on the entry level job requirements, and so on. I definitely think that seeing the recent trends, recent kind of RFEs on specialty occupation, I do suspect that that will again come back in 2025. In 2017, 2018, we saw the same problem. So back then, they used to argue that computer programmer, for example, is not specialty occupation anymore. So we saw a whole bunch of RFEs, a whole bunch of denials back in 2017 for computer programmers. So if there is renewed scrutiny on specialty occupation, what is going to happen is we will have to wait and watch and see what kind of occupations will be challenging, because USCIS can come back and change a few things around specialty occupation and argue a few occupations are not specialized. And going back to the historical evidences that we have, the computer programmer is a good example, because in 2017 we had a huge problem with computer programmer specialty occupation issues. And then the wage levels. 2017, when President Trump first took the office, all of a sudden we suddenly started seeing wage level RFEs, wage level one. So until then, we have never seen wage level one RFEs, and all of a sudden, USCIS was arguing that wage level one is probably not appropriate for specialty occupation. We still see it, but on a very, very reduced level. So, more than likely, I think we might see a renewed focus on wage level one cases. It will not be a blanket denial, but I can expect more RFEs on the wage levels. And the usual things that normally happen, the degree requirements, beneficiary qualifications, experience of the employees. So, those kind of things I think will still happen with renewed scrutiny. So, that's pretty much what I think we definitely can anticipate in 2025.
Yes, definitely. And we are looking ahead, like you have mentioned earlier, Trump's second rule, and we can expect many things to come back. And well, he may make it a little more difficult for, immigrants out there, if possible, maybe making it harder with RFEs. But let's see what can we expect, and
Yeah.
we will unfold this further as we keep on discussing today in this episode. And we also have Balakrishnan, who has another question. And Balakrishnan, thank you so much for joining us on YouTube. Please stay with us. We will address your questions. But yes, for now, Chand, another question, is that in cases where an employer is a startup or a small company, what specific documentation might USCIS request in an RFE to prove the viability of the H-1B position?
So whenever so on the I-129 form, the form that is used for filing for H-1B, there is a question that talks about the number of employees that the company has and also the income of the company. So upfront, USCIS will be looking at the nature of the company, whether it's a small startup or whether it is a big company or the revenues are low and so on. Apart from that, USGS also does a vibe check. So they do a check where they do a background check to see the nature of the company. Things like what's coming up on various reports, the DNB report, and so on. They typically will be analyzed. And if USCIS they feel that the company is a very small company or the company is a small startup, it is pretty normal to uh, question whether the position is even viable because the salaries on H1B they are very high salaries. It's very common to see a six-figure salary for a IT professional on H1B. The average salary nowadays is around like $95,000 to $100,000 on an average for IT professions. So when you are required to pay such a high salary to your employee and the company's financials or the nature of the company doesn't look like it has the money to pay for such a high tech employment, it's only normal that USCIS will question the startup. So when that happens, so what you are supposed to do is you're supposed to submit a detailed business plan. Sometimes USCIS may just come back and ask for a comprehensive business plan. Lately, we have not been seeing those RFEs, but in the past, it was very common where USCIS came back and put a lot of emphasis on marketing analysis, cost analysis, financial projections, the nature of funding for the in-house projects, if it is an in-house project, the nature of the contract, if it is a third-party contract, the duration of the contract, whether it is a short-term duration, whether it's a long-term duration. So all the things are possible, and USCIS, it these kind of documents help USCIS to understand the company's operations, and it also helps to prove to USCIS that the position offered is legitimate and bona fide. And not only that, it is also essential and it is a position that is in the regular course of the company's business. So that is very important. And what that means is small and startup companies, they should always ensure that their financial documents are readily available and logically prove that they have the resources to support the H-1B employment. So things like bank statements, profit and loss statements, tax returns, and sometimes if the company is a very, very brand new company, maybe things like investor funding or capital funding, because sometimes it's a startup. The people who are starting the business, they're actually investing into the company. So evidences of investor funding. So these are all good evidences because we do want to show that the company is financially stable or financially able to support this H1B position. So that's very important. And for small companies, another important thing is the detailed job description. So the detailed job description specifying what exactly the employee is doing and how that is relevant to the company's line of business. Sometimes a small company could even be an IT consulting company. Sometimes it is a product company. Sometimes it could be an implementation partner. It could be anything. And it has to be, this job description has to be relevant to the regular course of business. It should also show how the employee can supervise, I mean, how the employer is supervising the employee. Because if it's a very small startup, sometimes USCIS will question on the specialty occupation. Because if the company is so small, USCIS wants to know who's doing the other non-specialized tasks, such as payroll, such as other non-technical functions that are required in the company. So sometimes you have to have an org chart to show how you're splitting up the specialized duties and non-specialized duties, and who's doing the non-specialized duties. Because a small companies sometimes tend to put all kinds of duties to the employee, because they're like only like 2 3 people shop. So USCIS, we need a very good demarcation of the duties, and only specialized duties have to be assigned to the employee. So these are the kind of things that USCIS is very interested, because their goal is to make sure the position is legitimate, the position is bona fide, and apart from that, they also want to make sure that the employee is not given all the tasks, such as HR, marketing, all those non-technical tasks to the employee, because the company is a small company and they're trying to get everything done by this employee. So the bottom line is, the job description should be very, very unique, specialized, and should focus on the technical part. Employee can only be assigned those duties that are a part of that occupation. So these are the kind of challenges that a small startup company could have. And the best way is document the nature of the company, provide various financial documents. Doing so, normally we typically don't have a problem. I've seen a lot of companies who have like 1 2 3 employees, and look for H-1Bs, file for H-1Bs. As long as the company is legitimate, the position is a bona fide job offer. Even if it's a small startup, yes, you can get an RFE, but in general, USCIS is pretty okay, as long as there is a logical reason, logical answer to the need for that position.
Absolutely. Thank you so much, Chand, for highlighting that and very important things to keep in mind. Thank you so much. And moving on, Chand, I have another question. And now this is, how has USCIS's scrutiny of the employer employee relationship changed in the recent RFEs for H-1B petitions? And what should employers be mindful of?
Yeah. So 2010 to 2020. So during President Obama's administration and President Trump's initial administration, those 10 years, USCIS had a lot of scrutiny on employer-employer relationship, especially for any IT consulting or IT services company that had a third-party work assignment. So anytime you have an IT consulting company where they had a full-time employee, their full-time employee was providing services at a client location. So that's a third-party work site. So for any of those cases, 2010, 2020, the scrutiny was very, very high. When I say the scrutiny was high, USCIS was asking for client letters and letters from every vendor that was involved in that chain. And if the client did not give a letter, denials were common. This used to happen. And the reason for that was they wanted to know what was the role of the client, what was the role of the vendor in that whole chain. And they wanted to look at all their letters to see how that supervision happened. So that was what used to happen. And in 2020, so there was this lawsuit by IT Serve against USCIS, the government, and IT Serve prevailed in that lawsuit. And what happened was, because of that lawsuit, USCIS went back and rescinded two of the prior USCIS memos. And that changed the entire definition of the employer-employer relationship. And because of that court case, what happened is, USCIS said, as long as you can show at least one of the factors, such as like right to pay or something, you are good to prove the employer-employer relationship. So if a company pays the employee, treating him as a full-time employee, that is enough to show employer-employer relationship. We don't need client letters, we don't need vendor letters, etc., to prove the employer-employer relationship. So what that meant is, starting from 2021 to 2000 right now to current timeline, the focus is very low on employer-employer relationship. The reason is, we don't need client letters to prove employer-employer relationship anymore. If the employer is just attesting to paying the salary, and employer is actually paying the salary, that is more than enough to prove the employer-employer relationship in the current format. So what that means is, the burden of proving employer-employer relationship has come down drastically in the last 4 years. That being said, we don't know what's going to happen in the next 4 years. because there are already proposals out there to change a few things, to change the definition of bona fide job offer, to change the definition of specialty occupation. So these were draft proposals that were published during Biden administration. And if President Trump's administration decides to make those rules finalized, the drafts finalized, things could change. So we don't know, but at this point of time, employer-employee relationship is not a huge factor like it used to be in the past. But starting next year, more than likely, it could again come back, where we might again have to submit client letters, vendor letters, clearly stating what is the role of each and every party in the chain of relationship.
All right. At least we know now what can we be ready for. So thank you so much, Chant, for highlighting that as well. And we also have Charwak with comments on YouTube. Charwak, please stay with us. We are going to address your questions in a little bit. Okay. For now, some more questions from my end, Chand. So this is if an applicant has held multiple roles with different employers under the H-1B visa. How can they prepare for an RFE questioning the job's specialty occupation status?
So again, we have this question a lot. The employee is working for one employer. He has a particular role, and he's transferring to a new employer. And when he transfers to a new employer, um, the role might not be the same. Sometimes the role could be different. For example, the employee is working as a software developer in the prior company. When he's transferring, he's changing his role. Maybe he has to work as a network administrator. Maybe he has to work as a data scientist or something different. Or sometimes what happens is the wages might be different. Maybe he's working in a very, very senior level role in another company with a wage level 4. And when he's doing a transfer and is coming to this new company, maybe he is not getting the same salary. Maybe it's a junior level role. So the role is different. And a lot of people get concerned and ask us, will that cause a problem that the role is different because it's a different employer, the role is different, and he has so many different roles in the past, and now the role is not similar to what they had in the past. Will that cause a problem? So per se, every role is different, every filing is different. And what that means is USCIS, I've never seen USCIS come back and say, in the past in a different company you worked in this role, your role is now different, explain. USCIS does not do that. But what USCIS does is they treat every petition independently. So if they have a petition in the past where the employee got an approval, and now you have another petition where a new employer is filing for a H-1B, they treat this new petition independent, and they don't really use the old petition and say, because we approved that, we'll approve this. This new petition is independent. They will still look at the job duties. They will still look at the wage levels. They will still look at the nature of the company. And when you talk about specialty occupation, if the job description is not clear, USCIS routinely comes back and says, "Hey, you're this new employer, whoever has filed the job." They will argue that this is probably not a specialty occupation job. And at that point of time, what the company has to do, or if you want to even avoid that kind of an RFE, the new employer will have to provide clear, detailed job description that aligns with the specialty occupation requirements, that aligns with the work experience or the education of the employee. The new employer has to explain why the employee has the relevant skills, either through an academic program or through a combination of academic program and work experience, why he is qualified to do this job. And by doing so, normally what happens is the specialty occupation RFE risk is minimized. So if the employer is not able to clearly define the job duties, clearly expand the job duties, and clearly able to articulate how the employee is qualified based on his education or work experience, we're going to see these kind of RFEs. So the bottom line is every job is different, every petition is different, but every time the company goes and applies for a H-1B, give very, very detailed job description and explain the relevant fields of study that are relevant for the job. So if the employer goes and says, we just require a bachelor's degree in any engineering field, that is probably not specialty occupation. So the employer has to go back and specify a bachelor's degree in a specific field. For example, computer science, information technology, etc. is required. The fields have to be very, very closely related. So you cannot say this job requires mechanical engineering, civil engineering, and computer science, because then the fields are not specialized. They're like very diverse. So So the way the employers should be attacking the whole H-1B filing is clear and nice job descriptions. Be very specific on what kind of degrees you require, and make sure that the degrees that they require are actually what are normal as per the industry standards. So you cannot go and say for a software developer, I require a civil engineering degree, because that is not what the industry standard is. The employers also have to align their degree requirement to the industry standard. So by doing so, they can minimize these kind of RFEs.
Right, right. Thank you so much, Chand. Those were very, very important points, and thank you so much for highlighting them. It's very important to address these issues correctly and in detail so that they work. I mean, why are they asking for an RFE? They just need more explanation on what you're stating there, and being more specific is more important, right, Chand?
That is that is correct. And again, whenever you get an RFE does not mean it's a bad thing or you're going to get a denial. Majority of the cases still get approved. So RFE is where the officer has a couple more questions and he's trying to get more answers and more evidence back from the petitioner. So RFE is not bad. Whenever somebody gets an RFE, you have to carefully look and see what's going on, and then try to explain and provide more information. And the best way is try not to even go to that situation, be in that situation. So try to be as detailed as possible. That being said, sometimes even if everything is perfect in a case, sometimes the officer might just issue an RFE because he might have some other additional questions. So RFE always does not mean that the petition filing had some issue. Sometimes it also means that the officer probably has some additional questions, and sometimes it might be just a mistake in the filing. But RFE is one good way, because people typically don't get a direct denial. RFE is one way where you're getting another chance from USCIS to explain your stand. So the beauty of H-1B is you always get an RFE, you always get a second chance. That being said, everybody's goal should be to minimize the RFE. So more detailed explanation, more clear filing is the best way to minimize an RFE. But if you do get an
Right.
RFE, you're in that unfortunate situation. Try to explain as clearly as possible. Majority of the cases, I see them getting approved after an RFE.
All right, that is good then. So, Chand, we should address some of our questions from our viewers, and we should take up Dheeraj's question. He says, "Hi, Chand, I have a question regarding my H-1B transfer." Hi, Dheeraj. Thank you so much for joining us on YouTube. So, currently, Dheeraj is on H-1B and he got a new opportunity in new company, and he says he would like to transfer. But initially, when he was filing the H-1B in June, he filed the H-1B as future employment starting from
Mhm.
October 2024. But due to few reasons, he could not join the current company on October 1st, but joined on November 1st. So during the transfer process, will he be having any issues or will he be facing any RFEs for this reason?
Uh, so again, this is a very common situation, because when you have people on H-1B, they're working for a company, and then sometimes they get a better offer. And when they get a better offer and the company applies for a H-1B transfer, what happens is an employee is working at this company, a new company files for a transfer, and once the new company files for a transfer, the common question that I get is, when do you have to start working for this new company, company B that has filed your transfer? And the answer for that is, you can file immediately after the company gets files the case, and the receipt is receipted. So you can start immediately once the case is filed, or you can wait until you get an approval. Number two. Number three, even after you get an approval, you can join them down the line if you're continuing to work for the company A, the first company. So as long as you're working for the company A, you can continue to work under the terms of company A's H-1B, and down the line you can go and join company B. So from a USCIS perspective, as long as you're maintaining your status, you're good, which means you can continue to work with company A and join company B down the line. Only thing is, the day you join them, you have to stop working for company A, and the day you join company B, you have to make sure that H-1B is still valid. If you do it, the timeline is probably not a big issue. So you don't really have to start on the day you get the receipt or the day you get the approval. You can join them later on, assuming that you're still maintaining status with the first employer.
All right. Well, Dheeraj, best thing is, I hope you got your answer, by the way. And if you still have any more questions or you want to have a conversation with Attorney Chand right now, you have this opportunity. You can dial this number on the screen, which you can see on top. The number is 425-436-6335, and they'll ask for an access code. And when they do, you just have to dial in 988-888 and just say hello. We'll be able to hear you. Thank you, Dheeraj, for your questions. Thank you, Chant, for taking that up. And let's go on to this next one. This is on Facebook from Mia Abu. I received the RFE on the November 2nd, 2024 about educational background. I think we will need more information on this, but anything you want to say on this, Chant?
Sure. I think Abu, I think what has happened is he probably got an RFE for beneficiary qualifications. This is one of the most common RFEs that we see nowadays. RFEs asking for beneficiaries qualifications and asking us to prove that the beneficiary has a US equivalent of a bachelor's degree in the required field. Uh, so the way you answer it is in two ways. One, you have to look at the education of the employee. So if your education is in the right field, is in exact, say for example, you have a degree, for example, from India in computer science, for example, and your job is in a computer profession, say for example, as a software developer. If that is the case, all you have to do is you have to do an evaluation of your education. So you send it to an evaluations company, a credentials evaluation company. You get an education evaluation done, and that's all you require to answer your RFE. If your education is in the right field, if that is the case, it's a very simple RFE. Simply get an evaluation done, evaluation of your foreign degrees, send it back. One way. The other thing is, what if your education is not in the right field? Say, for example, you have a degree that's not in a relevant field. Say, for example, you have a degree in mechanical engineering and your job is as a software developer. When your education is not relevant to the job in question, if that is the case, what you're supposed to do is you are supposed to gather all your experience letters. So, gather each and every experience letter where you had worked in the past and gather your educational documents, and then have your employer send them to a university professor. So university professor in US. So there are a lot of companies that will help with professor evaluations. And what you're supposed to do is do something called a combined evaluation of both your academics, your education, plus your work experience. So when you do a combined evaluation of your academics and work experience, the US professor will be able to do an evaluation and see if it is equivalent to a US degree in computer science or a relevant field. And if that is the case, when they add up your experience, if they see that you have an equivalent degree, then you can use that to send it to USCIS, and USCIS typically will agree to a professor evaluation. So your RFE is not a very complex RFE. You just have to see if you have the right education, and if you don't have the right education, do you have the relevant experience? And based on that, get an evaluation done, provide the evaluation copy back to USCIS, and that is the way to um, tackle this RFE.
Thank you so much, Chand. Thank you so much. And thank you, Mia Abu. I hope you got your answer. But if you have any further details about your case, you can keep commenting. And better even, you can just call us on this number, which is displayed on the screen above.
Yeah, I think
Now-
yeah, I think
Yeah.
he's added a comment. He said education is not relevant to the job. So if education is
Okay.
not relevant to the job, what you will do is you will gather all your work experience letters. So do a evaluation with education and work experience together. So together, when you combine the experience, the professor might be able to see if you're qualified or not. And if you have the right experience in the past, definitely you should not have a problem.
All right. There you go, Mia. Thank you so much, Chand, for taking it up. Now, moving on, let's take up Balakrishnan's comment. This is also on YouTube. He's asking, do you think USCIS will focus more on RFEs about the employer employee relationship in 2025? We've already touched on this a bit. His next part of the question is, what steps should employers take to avoid these kinds of RFEs?
Sure. Because right now, if USCIS gives an RFE on employer-employer relationship, we can just use the right to pay to prove that there is an employer-employee relationship. So right now it is like very easy to prove. So what could happen is, if you see what has happened in 2010. In 2010, there was this USCIS memo called Newfield memo. So they issued a memo, and once the memo was issued, they started issuing RFEs on employer-employee relationship. Same thing happened again in 2017-18. They again issued another memo, and based on that, they used to issue RFEs. So right now, before USCIS can again issue RFEs on employer-employee relationship, I mean, I say RFEs, complex RFEs, they more than likely will have to do some rule changes. So if the rule changes happen, then yes, we might see these kind of RFEs. Will rule changes happen? It is a possibility. But what happened in the past is USCIS came out with these memos without following the proper APA, Administrative Procedure Act. So without following the proper APA procedure, they came with memos, which is why they lost in the court. So there was a court battle, and in the court they did not prevail. So next time, I think if at all they want to renew focus on employer-employee relationship, especially for the third-party worksite kind of companies, they will have to basically do a lot of things. A lot of things, as in follow the proper procedure. They have to basically tell what their proposed rule is, let the public comment. Once that is over, publish what is the final rule, and again give some time, and then finalize the rule. So if they follow the entire procedure, yes, it is possible. So I don't think it is something that is going to happen very quickly like it happened in the past, because in the past they just came out with a memo and all of a sudden they started issuing RFEs. And because the court said no, that is a violation of APA, more than likely they probably will not take a hasty decision this time, but probably do sequentially follow all the procedure and do it. If they do it, then definitely I think we will see RFEs. And to see what kind of steps employers should take to avoid these kind of RFEs, that is where we see before they make the rule changes, there is a big process. They will publish the draft. They will let all everybody that is impacted comment on the rules. So USCIS looks at comments. They try to kind of reason and do things the proper way, which is why we even have this entire APA, this Administrative Procedure Act. Uh, and by doing so, I think we will know what kind of steps we have to take before the rule gets finalized. But at least as of now, it is not something that will happen overnight. So we have time, because we will have to wait and watch and see how the rule making process will happen, to see how to basically legally show that we maintain employer-employee relationship if something is going to change in the future.
All right. Thank you so much, Chand, for taking that up. And we are going to address Balakrishnan's next question, but we have a caller right now, so I'm very excited about this. Hi, hello, can you hear us?
Yeah, I can hear you. Can you hear me?
Yes, we can. So, may I know where are you speaking from and what is your name? And please tell us what is your question.
Oh, sure. This is Dheeraj here, and I'm from Dallas. I'm in year two Denton. And I think like I have posted a comment before, but I need few more clarification on that. So that's the reason for calling you. So yeah,
Th-
hi, Chand. So I have a yeah. Sorry.
yeah, thank you so much, Dheeraj. Yes, very, very lovely to have you. And Chand is also from Dallas itself. So, yes, please
Yeah,
go
he's
ahead.
from my list. Yeah. Yeah. Hi, Chand. Good afternoon. Nice to speak to you. And
Hey,
so I have a
Dheeraj.
question regarding my H-1B transfer, Chand. So basically, I'll say a
Mhm.
whole scenario so that you can get a better understanding of what I'm facing, and you can answer on that. So
Mhm.
currently, like I'm on
Sure.
H-1B, and I got like H-1B this year. In October. So in my I-797A, like the effective date is from October 1st, but I did not join the
Mhm.
company, like filed my H-1B on October 1st, but I joined from November 1st. So basically, like now I got a new offer from another company, like one of the top company. So I just want to transfer my H-1B to the other company. So I just have a question, like because in I-797A the effective date is from October 1st, but I could not join on October 1st. But I joined on November 1st. So during this transfer process, will there be any issues? Because I should join on October 1st, but due to the reasons I could not join. So if I transfer to the new company, will they be asking any documents, or they'll be asking any kind of information about like why there is gap between like October 1st to October 31st? So I just want to know so will there be any issues in the future,
Sure.
or
Yeah.
anything
Yeah.
like that?
Yeah.
If you could.
Sh- sh- yeah. I think. I think it makes sense to me now, and I'll explain. I think what you're asking. I think you had a new cap filing, and the cap filing, the approval start date is from October 1st. I'm assuming you have a change of status approval. So when you have a change of status approval that
Yes,
starts from October 1st, yeah, what needs to happen is you're supposed to start on October 1st, and in your case, you started on November 1st. And when you apply for a transfer, one of the primary things that USCIS is looking for is did you maintain status in the past H-1B period? And the way they see that is they ask for your pay stubs. So when they ask for your pay stubs, and if they see that there is like a major issue, sometimes what they do is they cause a problem, and they can still approve the case. And more than likely, that is what will happen in your case. They can still approve the case because you are eligible for transferring, and the case will get approved. The place where you might have an issue is getting the I-94. So USCIS can deny the I-94 and ask you to go for stamping. So USCIS will not deny the H-1B for the reason that you mentioned, but USCIS could ask you to go for stamping if they find that for a certain amount of time you did not maintain status. In your case, it is less than 30 days, so you might get lucky. But again, the worst that could happen is USCIS will say, because you failed to maintain status, we will approve the case without an I-94. And that is what I see happen when there are major violations with maintaining status. And what that means is you go out of the country and then come back. Even last year, I had some cases where people did not join on time. And again, if it's a major issue, USCIS will say go out for stamping and come back. They will not issue the I-94. And sometimes if the violation is not big, in their discretion, they might let it go. So, so, so the summary is your transfer will not have a problem. They will approve the H1, but whether they will issue the I-94 where you don't have to leave the country, or they will not issue the I-94 but make you go out for stamping, that is where the issue could be. But again, from a transfer perspective, because you crossed October 1st, the transfer by itself will not be a problem. You are cap exempt. Okay, so whether you have to go out for stamping or not is probably the only question that USS might come back with because of the issue you mentioned.
Okay, okay. So what are the remedies should I follow to avoid that, or will there be any
I mean, what I would
meeting
do
with
is
the
just document what happened for that 1 month. I mean, again, there is no remedy. You did not work, you did not work. But again, if there is any logical reason, I mean, try to
yeah?
basically just document that part. Since it's only 30 days, I mean, I don't think long term you'll have very severe repercussion. But again, document your reasons to minimize the damage, because the reason that you said is not a reason to deny your H1. So they will not deny your H1 for that reason. Okay, so but again, let your, because one of the things that your the attorney for your transfer company, they will more than likely ask for your pay statements, and they will let you know what to do. At this point of time, I think you should probably, I mean, continue with your transfer. I don't think it's a fatal mistake.
Okay, okay, sure, Chan. So, I mean, I'll be getting the pay stub for November month in 4 to 5 days. Like from November 1st to November 31st, like which I have worked, I'll be getting that pay stub in like 2 to 3 days. So that would be fine, like to submit to the USCS. I mean, I have the previous three pay
Well,
stubs.
I think your attorney will tell you more. There's a little bit more than that. I mean, your case is a little bit more complex. From your side, I think what I will tell you is it is not. I mean, your transfer probably will not get denied, but your attorney is probably going to work with you. Okay, because the pay statement is missing, so you'll probably have some documentation to do with your other attorney, the company that's filing the transfer. But on a high level, I think you are still eligible to do a transfer. It is not that you're ineligible for this reason.
All right. So, thank you so much, Dheeraj. And I think if you have any further questions, you can also contact Attorney Chand directly, have a one on one discussion. And his phone number is 817 523 8247. It's on the screen. You can also email Chand. You can tell him that you contacted him on Immigration and Jobs Talk Show, and let him know that you're the same Dheeraj. So his email address is law@spblawfirm.com, and you can also go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. And thank you so much, Dheeraj, for calling in. And I
Thank you
hope.
so much. Yeah, thank you so much, Shan, and thank you so much. Thank you
Thank
so
you,
much
Dheeraj.
for the
Yeah.
introduction. Thank you.
Thank you, Dheeraj. So thank you, Chand, and for addressing that and taking, giving us what we needed, especially Dheeraj. So moving on now, Chand, we have Charwak's question. Oh, sorry, I was saying about Balakrishnan's another question. It's very interesting, actually. It's about AI. So for tech jobs like AI, will USCIS make it tougher in 2025? Sorry about that. 2025 to prove the role qualifies as a specialty occupation, and how can we handle RFEs if the job is in a rapidly changing field?
Right. And I think that is what I mean. I think only time will tell. But again, in the past, we have seen where all of a sudden USCIS will change an occupation, and all of a sudden, an occupation which was very specialized all of a sudden becomes an occupation that is not that specialized. And to give an example, just recently, in last 2 3 months, there is this occupation called computer systems engineers. There is an ONET code for it, and the entry level requirement was a bachelor's degree till 2 3 months back, and all of a sudden that got changed to something where it does not require a bachelor's degree on entry level. So things like that could happen, and because the IT profession is so dynamic, so within IT profession there are some fields like web developers. USCIS stand, the occupational outlook handbook stand is that it is not I mean, at entry level it does not require a bachelor's degree. So so the yardstick for USCIS currently is they go and look at the occupational outlook handbook. They will look at that occupation and they will see what the OOH is talking about the occupation. For example, if you go to this occupational outlook handbook, you look for software developer, or you look for data scientist, or you look for computer programmer right now. The entry level requires a bachelor's degree. So upfront it says that it requires a bachelor's degree. So USCIS more than likely will not question about specialty occupation. But again, there are some occupations in IT industry which are pretty popular, but OOH on an entry level does not require a bachelor's degree. So those kind of challenges are possible, and since AI or the tech industry is so dynamic, what is a specialty occupation today might not be a specialty occupation down the line. So this is going to be a challenge. And normally, as a lawyer or as a legal professional, what we do is we look at the industry standards. We look at the same set of standards that USCIS sees. And normally, when I see a job that comes in an occupation that could be challenged, we let the employers know that this is an occupation that could be challenging. And sometimes maybe it's a very senior level role, not an entry level role. So even though at entry level it does not require a bachelor's degree, maybe at a higher level it requires higher wage level, it requires a bachelor's degree. So there are so many things that could go on, and there are rules on what USCIS should look for. So there are ways to prove an occupation is a specialty occupation, and I definitely think in 2025 we will at least see some challenges with some of these occupations. And to give an exact equivalent, in 2017 we had a challenge with computer programmers, which we thought all along was a specialized field. Back in 2017 we had a challenge, and 2017 to 2020 we had so many challenges with computer programmer occupation. After 2020, computer programmers again, I think, was accepted. So when I say computer programmer, this is different from software developer. Software developer never had a challenge. Computer programmer had a challenge in those years. So hopefully, all of us will keep up with what's going on in terms of rule changes next year, and we just have to look out. And employers have to be careful, because if it's an occupation that USCIS does not treat as specialized occupation, they have to think twice before filing a petition in that occupation.
Right, right. Thank you so much, Sean, for addressing that and for also giving us a few examples. And at this moment, I would like to address few questions from our Facebook group. So I'm sharing my screen. And we have this first one. This is from an anonymous member saying, I just want to share my experience on my AOS process as a B2 holder who married USC. Came here last year on a B2 visa, married my long time BF after 30 days since I got here. Filed all the forms after 90 days since we got married, and finally I got my approval. God is so good. Just waiting for my green card to arrive. Thank you to this. Okay. I did my DIY, no lawyer, compiled all the RFEs asked. Okay, I think there's not much here. Let me take this next question. This is from
Mhm.
Joseph. Hello, I got laid off from Intel Corporation and I'm almost at the end of my H-1B grace period. I have to transfer my H-1B to a new employer by December 20th to legally stay in the US. Other visa options like B2, F1 are not applicable for my case. Please let me know if you know. Okay. My background is mechanical engineering and manufacturing engineering. There are ITCS consultancies out there to do my H-1B transfers. Well, the question is, well, if you have anything, anything to say to Joseph Chand.
Yeah. So I think what he's trying to do is he's trying to find a IT, just a consulting company just to transfer his H1B. And he's talking about I can run my own payroll. Upfront, that is illegal. I mean, if they're trying to do something where he's running his own payroll, what that means is he's paying somebody to stay in status. That is more than, I mean, that is upfront illegal. And you cannot transfer to a company and start paying your own payroll taxes because that is fraud. It's fraud and misrepresentation. There is no bona fide job offer. So you have to be cautious. And then uh, again, like if your background is in one field and an IT company is filing for an IT job, US is going to question on the nature of your qualifications. So overall, I mean, again, the rule is you have 60 days. Within 60 days, you have to find a bona fide job offer, not like any H1B transfer, because you get a H1B transfer filed and it is not a bona fide job, and USCIS tomorrow finds out about it, or at the consulate, the consular officer digs into your petition. Tomorrow, you could have a lifetime ban. For any misrepresentation or fraud, you can run into issues. So don't just go to any random companies because you want to stay in status, pay them money, or tell them to run your payroll. Running payroll, that is illegal. I mean, when you say I'm paying my taxes to run the payroll, that is illegal. If the company is filing a H1B, you're working for them, they're supposed to pay you. Benching is illegal. So a company cannot bench you and say you pay the payroll taxes, we'll run the payroll. So that is illegal. So just be cautious and stay away from any kind of things that could get you in trouble. And misrepresentation will get you in trouble with a permanent bar to US down the line.
All right. Thank you so much, Chand, for taking that up for Joseph. All right, moving on, we have another one. This is from an anonymous member. I need help. My case status for all family members, four of them, shows that an RFE has been issued on 4th November. Though I received only one kid RFE and never received other three RFEs. Called chatted agents, okay. They said they don't have digital copy of other three RFEs, so can't send on email. It's been almost 1 month, and no one in USCIS knows that what is RFE about. And they said office that has file has been notified. What should I do?
Yeah, I think when he's like trying to like call or chat with the agents, they're probably like I think they're just the front end staff, so they're not able to see what's going on. But what he should do is go to USCIS website, and under USCIS website there is an option to create service requests. So create a service request, and one of the things is lost or not received notices. So you'll see that option clearly. Click on that option, create a service ticket, because that is your evidence. Once you create the ticket, you should get an email back saying that they've received your ticket, and within a certain timeline, USCIS should respond back. Because when you create a ticket, it goes into the ticketing system, and somebody will research on what exactly is going on. So give the receipt number, create a ticket with that information, and then internally they will check and they'll have to investigate what's going on. And USCIS always will respond before 30 days most of the time. So instead of chatting with the agents, where tomorrow you might not even have any proper log or proof, go to the USCIS website and look for this option that says the creating a ticket, and create a service request, and there is a clear service request option for lost or not received notices. So make sure you create the ticket. That's also your proof down the line. If something happens, you have notified USCIS that you have not received the notice. And normally, if you create that kind of a ticket, they usually respond back and they usually will resend the notice back to you.
Right. So thank you so much, Chand, for taking that up. And I think we can have the next one from Control. Um, Thank you so much, Chand, for taking that up. So we have this next one. If it's been almost 4 months since USCIS received my application, but they haven't sent my RFEs, does that, sorry, Control, can I have it back on the screen, please? All right, so let me just read it out from my screen. It's been almost 4 months since USCIS received my application, but they haven't sent any RFEs. Does that mean everything we sent is enough? Or could they still ask for more? PD 8/8/2024 biometrics are done. So far, my interview is waived. I know this can change. I'm just curious. Okay.
Yeah, since I think the post is talking about priority date and biometrics are done, my guess is this is for more than likely a green card filing, adjustment of status filing. And for an adjustment of status filing, 4 months is probably just, I mean, it's just recent application. And right now, it does not mean everything is enough, or it does not mean something is wrong. They're still processing the application, and hopefully, in the next couple of months, you will hear something about it. But 4 months is too early for these kind of applications. And in the next couple of months, hopefully, you'll find something. And again, if you get an RFE, you get 87 days in general. Respond back quickly. If you don't get an RFE, you get a direct approval. That is also very good. And I think, like you mentioned, that more than likely your interview got waived. That is a very, very big possibility because nowadays, not many people get interviews because of the interview waivers for AOS applications. So hopefully your interview is waived and you get a very speedy approval. But again, 4 months I think is like too early. So next couple of months you should have an answer.
All right. Thank you so much, Chand, for taking that up. Now, moving on to my next one. This is, um, okay. I think I have to do it from my screen. So let me just. So this one is, what are probable RFEs for EB1C on H1B?
Uh, so when we talk about EB1C, what it means is somebody has worked as a manager in a foreign office and they're coming over to US office to work as a manager. So even if somebody's on H-1B, they don't have to be on L-1A. Even if somebody's on H-1B and if they are qualified, you can always do a EB1C I-140. So the most common things that we see on EB1C is whether the foreign office and the US office are they properly connected, because there is a specific way in which the companies have to be connected to qualify for EB1C. So the relationship between the foreign entity and the US entity. So this is one of the common RFEs that we see. And another common RFE that we normally see is the managerial duties. What kind of managerial duties did you have in the back in the foreign office? What kind of managerial duties do you have in the US office? So it's typically on the managerial aspects we see RFEs, or on the company to company relationship, how the companies are related. Are they affiliates? Are they subsidiaries? Is it like a parent company owning a child company? So these are typically the most common RFEs that we see. And if most of the time it's also with the duties, because it is a managerial intra company managerial transfer. So they want to make sure somebody worked as a manager, somebody's going to work as a manager in the foreign is coming to work in US office from a foreign office to work as a manager. So that's where most of the scrutiny is going to be.
Thank you so much, Chand, for taking that up. And let's go on to this next one. This is from an anonymous member. Help. I just got married end of last month. We want to get in line ASAP for AOS before Trump sits in. We trying our best to complete the I-130 and I-485 package, and my husband is cooperative, but we wanted to avoid RFEs too. Does it even matter at this point if we submit it this year versus next year?
Um, so what will happen is even if they apply this month or next month, I don't think the package will be opened and the officer is going to be like reviewing that application immediately. And that's why there is a processing time. The I-130s and I-485s take a couple of months to be approved or even issued an RFE. So whether they apply today or tomorrow, say for example, come February or March, there are some rule changes. I mean, again, the new rule changes probably will not be retroactive, but the scrutiny will always be there. So again, if in the future, if you don't apply now, the rules could change and it could complicate your process. To give an example, what happened during the last President Trump's administration was they changed the I-485 application. They added a lot more public charge questions. So doing that public charge, they even added a form. So it became a very complex process. And right now in the I-485, the public charge part is pretty simple. So if you ask me whether if you wait, things will change, they can definitely change the process. They can pretty much change the forms and ask for more information, and it could complicate the form. So from that perspective, yes, do it as quickly as possible. But even if you do it today, you're not going to get an approval in like a month. It's going to take a couple of months, and it all depends on what kind of rule changes we'll get in the future, what kind of additional things they might ask in the future, and so on. But I definitely would file it as soon as you can, because at least now we know that the forms are not changing anytime soon. And if the forms change, you have to redo all the forms, and the forms are complex. So again, whether you get an approval in a month or not, it doesn't matter. I think go ahead and finish it off. So that way, it's one thing out of the way.
All right. Thank you so much, Chand, for addressing that. And if you have a couple more minutes, I think we can go on. Yes, so we'll take this one from Mona
Sure, sure.
Lisa. Hi, I recently received a request for evidence from USCIS requesting details about my employer and the e verify number. I'm feeling a bit unsure about how to structure my response and would appreciate any advice or guidance. If you have experience with responding RFEs, navigating USCIS process, I would be grateful if you could share and help me with any tips, insights, or examples of successful responses.
This RFE is I mean, I've seen this RFE a lot of times for STEM OPT extensions. So when somebody who's on OPT is trying to apply for a STEM OPT, that E-Verify number is pretty important. And if sometimes some employer accidentally puts the number wrong and USS is not able to see a result for that, they issue these kind of RFEs. So the easiest thing is like just show that RFE to your employer, check with them on the E-Verify number, make sure they're able to re-verify, give you the documentation, and attach the documentation as a part of your RFE response and respond back. So, I mean, it's probably a simple RFE where they got some digits wrong. Confirm with the
Okay.
employer, send them the right e-verify number, and more than likely should not have an issue.
Okay, great. Thank you for taking that up for Mona Lisa. Now, this last one, this is from, yeah, let's have it on screen control. Trivikram. Hi all, I am on H-1B and working as a contractor. My spouse is on H-4 EAD and she is working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
So, anytime somebody is on H1 and then doing a transfer, the transfer from one employer to another employer, if the spouse is on H4 and H4 EAD, you don't have to really again apply for H4 and H4 EAD. If the H4 and H4 EAD is still valid, uh, when the principal H1B spouse transfers his employment, the H4 EAD automatically transfers over. So the H4 EAD is still valid till the end date on the H4 EAD. So you can just, if you get a better offer, you can move your employment to this new employer. Your spouse who's having a current H4 and H4 EAD, they are still valid to use that H4 EAD till whatever time that H4 EAD permits them. Only thing is look at the H4 EAD closely, H4 closely. Make sure you file for an extension before they expire. You don't have to file for a transfer right away. So they are good to go. So the H4 EAD spouse should not have any problem at all.
Awesome. Thank you so much, Chand. That was great. You patiently took up so many of our questions, addressed so many of our viewers' questions, and it was so exciting to have Dheeraj on call, our first caller. So thank you so much, Dheeraj, for joining us. And please contact Attorney Chand Parvathaneni for further consultation and to get to know more on your case. Thank you so much, Chand. And maybe, we can cover this topic again in the coming week if you want to, Chand. But for now, I think
Definitely.
we'll have
Yeah.
to wrap up. And whatever you have to say as an end note to all our viewers who are watching us right now, it would be great to know.
Sure. And I mean, I think the big thing is, I think again, compliance. We talk about compliance a lot of times. Everybody has to comply with the regulations, the government regulations. So I mean, again, a lot of people. I think there's a lot of scaremongering going around in the all around. And President Trump, we have seen President Trump in 2016 to 2020. He definitely appreciates the value of H-1B program. He's not going to abolish that program. He is more about refining the program because I think in some ways uh, they're correct. There is fraud in H-1B program. We always see issues. We see this RFEs talk about fraud, misrepresentation. So the administration is more concerned about the fraud, misrepresentation, those kind of issues. They want to refine the program. And what that means is they keep changing rules. And sometimes the rule changes because they come all of a sudden. People are taken aback, and in short term, it causes a lot of issues. But I think nobody's trying to abolish this program, or nobody's trying to like completely cut this program, because H-1B program adds a lot of value to US economy. It adds a lot of value to the tech industry. US tech industry will not survive without the H-1B program. There's a lot of value addition that happens because these employees who are highly educated, highly specialized, bring a lot uh, to the technological innovations that are happening in US. So H-1B program will always be a valued program. I think they might try to cut the fraud that is happening in the program. They want to strengthen this program. And I think the administration, the rule changes that you see will all be towards refining the program. What that means to all the employees is work for a reliable company. Don't work for any random company which you think is probably not a reliable company. As long as you're working for a reliable company, even if it's a small company, even if it's a consulting company, even if it's a full-time startup or a big company, it doesn't matter. It has to be a legitimate company. As long as it's a legitimate company that is doing business and it's been in business, you know that they have other employees, you are good. But again, if a company is a fraudulent company, you will know the way they talk to you, the way they're paying you. So don't work with any company that is not following the regulations. If a company is following the regulations, it doesn't matter. Small company, big company, doesn't matter. You will be okay. So the bottom line is try to work within the framework of the regulations, work for a legitimate employer, and more than likely you should not have any issue.
Absolutely. Thank you so much, Chand, for joining us today. It was really great having you in this discussion. Very, very insightful discussion, and so much we got to learn from you today. And I'm excited to have you back. I hope you can join us again in the coming week.
Sure, Nipasa. See you again next week.
See you, Chand. Have a great day ahead. Thank you once again.
You, you too.
So, folks out there, thank you so much for joining us, and really great to have you all. If you want to contact Attorney Chand Parvathaneni and have a one-on-one consultation regarding your case, you can call him up on this number, 817-523-8247. And you can also email Chand. His email address is law@spblawfirm.com. And you can also go visit his website, www.spblawfirm.com. And thank you, each one of you, for joining us. You can also contact me, by the way. My phone number is 408-335-6444. And you can also email me. My email address is nipa@staffingly.com. And another very exciting thing is that we have daily immigration dose from Monday to Friday at 4 p.m. Eastern Time. So in, say, about 15 minutes or so, we are going to join in again. So stay tuned to Immigration and Jobs Talk Show. Thank you, each one of you, for joining us once again. And yeah, bye bye for now.